está diciendo? Su mom and dad, you know?
Oh, I gotta shave you.
And then where are we going?
Let's go.
What? I'm gonna kick his ass. Fucking whoop him.
No?
I've been talking shit all week
Está
long.
grabado, dude. Jesus, man. Party battle.
Oh yay, oh yay, oh yay. The Honorable Supreme Court of the United States is now in session. Justice Calabresi, Gregory, and Gibbons presiding. Please be seated.
There's like nobody, it's about to start, so.
Good afternoon, Your Honors, or good evening. May it please the Court. My name is Andres Correa, and I represent Respondent Mr. Winston Smith in her address of a teacher's classroom speech. And my co-counsel, Ms. Kelly Gray, will address the second issue of specialty license plates. Your Honors, the freedom of speech is essential to the rich and effective education of our youth. Now, this Court has the opportunity today to ensure that Mr. Smith's classroom instruction continues to thrive in the classroom, that his students continue to learn in the classroom by keeping the classroom within the shelter that the First Amendment affords it. Now, this Court can do so by affirming the Court of Appeals in one of two ways. First, it can adopt a new standard, a standard that we propose that is more specifically crafted to the unique relationship between the First Amendment and classroom speech. Or, alternatively, second, it can uphold the Court of Appeals and its application of the public employee approach to a teacher's classroom speech. So first, we do propose that this Court actually adopt a new standard, because the current existing standards do not adequately encompass that relationship, the critical role of the First Amendment.
So you can't meet the Tinker standard?
It's a much closer question, Your Honor. You're right. It is, but we do not concede that we do not meet it. And specifically, because if the question is whether the actions taken here were reasonably related to a legitimate pedagogical concern, we have to consider the actions taken, which was the definite suspension of Mr. Smith without pay for merely showing a film that he had not been given any notice whatsoever. In fact, quite the opposite. He had been told, you may supplement the curriculum. You may go beyond the curriculum.
That's a film that it's highly explosive. Have you seen, counsel, that film shows that blacks in Reconstruction Congress, rather than considering the agenda of the day, were actually throwing chicken bones across the aisle and picking their feet and saying, I'm just glad to be here. Isn't that so explosive and so raw and mean that runs counter to pedagogical interest? And can a school board say, we don't want that?
Insofar as the purpose is to educate students, to have them understand U.S. history, then it is that precise rawness of this film that is perhaps the only way for students to truly understand the nature of racism.
Perhaps, but who is to decide what is appropriate in the school other than the school board? No one is saying that this movie can't be seen outside. No one is saying that people can't picket that movie if it is seen, and other people can support it. That's what the First Amendment is about. But this is a school, and somebody has to decide what kinds of things are appropriate to the school, rather than just let a teacher can do this. Teacher can come in and say almost anything and would be protected, wouldn't they?
You're right, Your Honor. The educational community is entitled to make any decisions, any of the complex decisions, but they must do so in ways that abide by the First Amendment, that abide by the Constitution. This power of a school board cannot be unlimited. And we see here precisely
what is the standard? I'm sympathetic to the notion that the standard in Tinker and Hazelwood was made with students in mind. And I don't think, though, that an employee standard, the Pickering standard, captures quite what is going on in a school. And the fact that you have a teacher doing something with respect to youngsters and someone else who is supposed to say, what is the standard you would have us have, which balances some degree, keeping a school board from going too far, but keeping a teacher from doing things which are damaging to children.
The standard, Your Honor, we propose is the following, and that we attempt to accomplish is that goal. And it's the following. A school may not retaliate against a teacher unless it can show one of two things. First, that the teacher's speech contravened the curriculum as communicated by the school to the teacher. Or second,
You mean that any time that a teacher does something new that is scandalous, the teacher's okay because it's a preordained curriculum violation?
Not necessarily, Your Honor, and that's because of the second prong. Under the second prong, it says that a school may not retaliate unless it can show, in the alternative, that a teacher's speech substantially impaired his ability to teach. So something scandalous, for example, something that may be a film in this case.
Impaired the ability to teach puts it back to whether other people objected to it rather than whether this was something that the school board found so offensive or the laws of the state found so offensive. I mean, I don't know what your second prong means, but I could read your second prong to mean you lose.
Well, that would be unfortunate, Your Honor. We urge you not to do that. But the second prong means looking at the facts of the record. The government has failed to put forth any indication that Mr. Smith's showing of this film has actually harmed his ability to teach in a classroom. First of all, his scores, the standardized test scores of his students are above average. The advanced placement scores of his AP U.S. History class in which this film was shown are the highest, not just in the school, but in the entire district. His peer reviews are...
Is there any data on whether they go out and become bigots?
There is no data on that, Your Honor. And we hope that
Not likely, but what good are the highest test scores in the world? I'm sure that Oklahoma could have pretty high test scores.
The test scores are only one indication of the effect, the extent to which a teacher is actually being effective. And in a perfect world, it's one thing we can use as somewhat of a measure to see how his students are actually doing.
How much of an impairment can it be on a teacher's ability to teach to have to choose something other than this particular film to teach a concept or an idea or history?
None whatsoever, Your Honor, as long as he is told beforehand that he should choose something else and not penalized in the way that he has been penalized here, after having been told and after showing other films that all of a sudden he may not do so and he is indefinitely suspended without pay. So we do not contest whether, for example, the school board, as part of the curriculum, may say the birth of a nation may not be shown. That may bring other issues such as viewpoint discrimination that are not necessarily an issue in this case. But what we do say is that when a teacher has been told explicitly that he may supplement the curriculum, and he does so by showing a film that is precisely the subject matter of a U.S. history classroom, he should not be penalized for it after the fact, because, as Justice Calabresi noted, of the extraordinarily chilling effect that this will have in the classroom.
Doesn't that mean that school systems have to think in advance about every single thing that might be thought of by a teacher? I mean, are we going to have very, very complicated and prescribed curriculum that might actually inhibit teachers in their ability to teach creatively?
No, Your Honor, not necessarily. The way we are arguing, as you may know, from the First Circuit in incorporating this notice, and the way the court in Ward stated this notice requirement is not that the school must list everything that's prohibited or everything that's allowed in a classroom, but instead that a court, when forced to do so, should look at all of the communication, should look at everything that the teacher was told of the communication between the school board.
Isn't the tradition, our First Amendment tradition, very much the other way, that we strike down almost any rules that are made in advance, but we are allowed to punish people afterwards? Isn't that the lesson of the Pentagon Papers, that we don't allow injunctions before something is published, but that if the thing does harm, is violative of certain rules, we can punish?
Well, if that is indeed the First Amendment's history, it should never be so in the classroom, Your Honor. And that is because, as again the Ward v. Hickey, the court noted, if teachers are to fear for retaliation for every utterance, they will fear teaching.